a different state within the U.S.
So a Delaware corporation doing business in California is considered foreign in California.
Exactly. To legally transact business in a state where it wasn't incorporated, the foreign state, a corporation must typically register with that state's authorities, usually the Secretary of State, and obtain a certificate of authority. This registration process ensures that state governments know who is conducting business within their borders, can subject them to state taxes, and provides a mechanism for serving legal process on them within the state.
What about businesses that provide professional services, like law firms, accounting firms, or medical practices? Can they just be regular corporations, or is there something special for them?
Often, they form what's called a professional corporation, often designated as PC or similar initials after their name. The key feature is that its stated purpose in the articles is statutorily limited to the rendering of a specific type of professional service for which all shareholders are licensed. E.g., a law firm PC can only practice law, a medical practice PC only medicine. While the PC structure generally provides limited liability for the business debts of the corporation, like rent or supplier contracts, it typically does not shield the individual professionals from personal liability for their own professional malpractice or negligence. So the corporate shield is slightly different for professional negligence claims.
And I've definitely heard people talk about S corporations. You mentioned C corporations earlier. How is an S corp different? Is it a totally separate legal entity type?
That's a common point of confusion. An S corporation is not a distinct type of corporate entity formed under state law like a C corp or a PC. Instead, it's a tax designation under the Federal Internal Revenue Code that a qualifying standard state law corporation, usually a C corp or even an LLC that elects to be taxed as a corp, can elect to adopt by filing a specific form with the IRS.
What's the main benefit of making that S election?
The primary benefit is that it avoids the potential double taxation inherent in the traditional C corporation structure. A C corporation pays corporate income tax on its profits, and then if it distributes those profits to shareholders as dividends, the shareholders pay personal income tax on those dividends again. An S corp, by contrast, generally does not pay corporate-level income tax. Instead, its income, losses, deductions, and credits are passed through directly to its shareholders on a pro rata basis, and the shareholders report that income or loss on their individual tax returns and pay tax at their individual rates. This pass-through taxation is similar to how partnerships and sole proprietorships are taxed, making it very attractive for many smaller businesses that want the liability protection of a corporation without the double tax hit. There are strict eligibility requirements for S-corp status, though, regarding the number and type of shareholders, classes of stock, etc. And one more relatively newer type worth mentioning is the benefit corporation, or B Corp. Though that term is also used for a third-party certification, the legal entity is a benefit corporation. This is a type of for-profit corporation, recognized now in many states, where its corporate purpose, as stated in its articles, is defined not just to maximize shareholder profit, but also to create a general public benefit, such as a positive impact on society or the environment.
So they have a dual mission, profit and purpose.
Exactly. The law explicitly allows, and sometimes requires, the directors of a benefit corporation to consider the impact of their decisions, not just on shareholders, but also on other stakeholders, like employees, the community, and the environment, when making business decisions. This provides a legal shield for directors against potential shareholder lawsuits claiming they breached their fiduciary duties by not prioritizing shareholder profit above all other considerations. It legally embeds a broader social purpose into the corporate DNA.
Okay, so corporations aren't a monolith. There are close core, PCs, S-corp tax status, benefit core, lots of variations for specific needs and even social missions. But what about that other major player we mentioned at the start, the one that seems to combine the best features of corporations and partnerships? Let's talk about the LLC.
All right, let's shift gears to the limited liability company, or LLC. It has become incredibly popular over the last few decades, and for good reason. It's truly a hybrid business entity, ingeniously designed to offer its owners, called members, the pass-through tax advantage typically associated with partnerships, meaning no entity-level income tax, profits, and losses pass through to the members' personal returns, combined with the robust limited liability protection for those members. That's the hallmark of a corporation.
Best of both worlds, essentially.
That's the goal. And while LLCs do have their own unique terminology, members instead of shareholders, operating agreement instead of bylaws, articles of organization instead of incorporation, and some distinct rules. Many of the core legal issues, fiduciary duties, liability shields, veil piercing, can often be analyzed using the general principles we've already discussed for corporations. There's a lot of overlap in the underlying legal concepts.
How do you actually create an LLC? Is it a similar state filing process to forming a corporation?
Very similar process, just different forms and names. An LLC is created by filing articles of organization with the designated state office, again, usually the Secretary of State. These articles are typically even simpler than corporate articles. They generally must include the LLC's name, which usually has to contain LLC or limited liability company, its principal mailing address, and often the name and address of its registered agent. Some states might require a bit more, like stating if it will be member-managed or manager-managed.
When does the LLC legally exist?
Like a corporation, existence typically begins upon filing, or a later specified date. However, an LLC generally doesn't actually come into full legal existence or function until it has at least one member. Interestingly, if there's a technical defect in the formation process, some states will apply doctrines analogous to de facto corporation and corporation by estoppel if there was a good faith effort to create the LLC, providing similar potential protection from personal liability for the members.
Do LLCs also have an internal rulebook, like corporate bylaws? You mentioned an operating agreement.
Yes, exactly. While the Articles of Organization are the public-facing document establishing the LLC's existence, the internal governance, member rights, profit loss allocation, and management structure are typically detailed in an operating agreement. This agreement is incredibly flexible. It's essentially a contract among the members, and sometimes with the LLC itself. It can be oral, it can be in a written record, or in some cases, it can even be implied by the member's course of conduct. This contractual flexibility is one of the biggest advantages of the LLC form compared to the more rigid statutory requirements for corporations. If the operating agreement is silent on a particular issue, then default rules under the state's LLC statute will apply, and often the default management structure is member-managed.
Okay, let's talk about membership in an LLC. How many members can it have? And what happens when members want to join or leave or maybe sell their interest to someone else? Is that easy?
An LLC must have at least one member to exist. There's generally no maximum limit on the number of members, making LLCs suitable for everything from single-person businesses to large investment funds with hundreds of members.
Joining and leaving.
Becoming a new member typically requires the consent of all existing members, unless the operating agreement specifically provides a different mechanism, like majority consent. This reflects the partnership heritage you choose your partners. Transferring a membership interest is also interesting. A member can usually transfer their financial interest, their right to receive distributions, and share in profits and losses to someone else. However, the transferee does not automatically become a full member with management or voting rights. They just get the economic rights. Becoming a substitute member with full rights typically, again, requires the consent of the other members, unless the operating agreement says otherwise.
What about members wanting to leave? Can they just walk away?
Generally, yes. A member usually has the power to dissociate or withdraw from the LLC at any time and for any reason, simply by giving notice, which often doesn't even need to be written. Unlike partnership law, where withdrawal could force dissolution, a member's dissociation from an LLC does not automatically trigger the dissolution and winding up of the LLC. The LLC continues to exist. The operating agreement or state law will typically dictate whether the LLC must or may buy out the fair value of the withdrawing member's interest.
How are profits and losses shared?
The default rule under most LLC statutes is that allocations of profits and losses are made according to each member's contributions to the LLC, based on the agreed value of those contributions. However, the operating agreement can, and very often does, provide for a different allocation method entirely, perhaps based on ownership percentages that differ from capital contributions or through more complex arrangements. Again, flexibility is key.
Do members have inspection rights like shareholders?
Yes. LLC members generally have rights to inspect and copy LLC records, similar to the rights of corporate shareholders, usually requiring a request made in good faith and for a proper purpose related to their interest as a member.
How is management actually handled in an LLC? You mentioned member-managed versus manager-managed. Is there no board of directors?
Correct. There's typically no statutory requirement for a board of directors in an LLC, although the members could create one contractually in their operating agreement if they wanted a corporate-style structure. The default management structure in many states, if the operating agreement is silent, is member-managed. In a member-managed LLC, all the members have the authority to manage the business and act as agents who can bind the LLC in its ordinary course of business, much like partners in a general partnership.
Okay, so all members run it by default. What's the alternative?
The alternative, which must be specified in the articles or operating agreement, is manager-managed. In a manager-managed LLC, the authority to manage the business and bind the LLC is vested in one or more designated managers. These managers don't necessarily have to be members of the LLC. They can be outsiders hired for their expertise. In this structure, the managers have the agency authority to bind the LLC, and the individual members who are not managers generally do not have the power to bind the entity, similar to shareholders in a corporation who don't run the business directly. The choice between these structures depends entirely on what the members want and agree to.
What about the main attraction, the limited liability? Is that shield as strong in an LLC as it is supposed to be in a corporation? And critically, can the LLC veil also be pierced, just like a corporate veil, holding members personally liable?
Generally, yes. The limited liability shield provided by the LLC statute is intended to be just as robust as the corporate shield. A manager acting for the LLC is typically not personally liable for obligations incurred on behalf of the LLC simply because they are a manager. And more importantly, a member is generally not personally liable for the LLC's debts, obligations, or liabilities solely by reason of being a member. So the limited liability shield is very much present and is a core feature.
But can it be pierced?
Yes, absolutely. Just like with corporations, members may be held personally liable for the LLC's obligations if a court decides to pierce the LLC veil. The factors courts consider when deciding whether to pierce the LLC veil are quite similar to those used for corporations. Things like serious undercapitalization, failure to observe formalities, though LLCs often have fewer required formalities, commingling of personal and LLC assets, using the LLC to perpetrate fraud or achieve an unfair result, or treating the LLC as the mere alter ego of a member. The underlying equitable principles for piercing are essentially the same. It's reserved for situations where the LLC form is being abused, and respecting the entity's separateness would lead to injustice.
What about those fiduciary duties we spent so much time on for directors and officers? Do members and managers of an LLC owe similar duties of loyalty and care to the LLC and its other members?
Yes, they generally do, although the specifics can sometimes be modified by the operating agreement more readily than in a corporation. In a member-managed LLC, the members themselves owe fiduciary duties of loyalty and care to the LLC and its other members. In a manager-managed LLC, it's the managers who owe these duties, while non-manager members generally do not owe fiduciary duties just by virtue of being members.
What do those duties entail in the LLC context, same as for corporations?
Pretty much the same core concepts. The duty of loyalty typically includes the duty to account to the LLC for any profit or benefit derived by the member manager in connection with the LLC's business, the duty to refrain from dealing with the LLC on behalf of a party having an adverse interest, unless properly disclosed and approved, and the duty to refrain from competing with the LLC. The duty of care generally requires members' managers to act with the care that a reasonably prudent person in a like position would exercise under similar circumstances. Importantly, this duty of care in the LLC context is often explicitly limited by statute to refraining from grossly negligent or reckless conduct, intentional misconduct, or knowing violations of law, meaning simple negligence is often not enough for liability, similar to the protection afforded by the business judgment rule in corporations.
You mentioned the operating agreement can modify these duties more easily. How does that work? That sounds like a key difference from corporate law.
Yes, this is a significant point of flexibility and difference. Fiduciary waivers or modifications are generally recognized and more permissible in LLC operating agreements than in corporate bylaws or charters. The members, in their operating agreement, can often agree to reasonably limit or define the scope of the duty of loyalty or the duty of care. For example, they might agree to allow members to pursue certain types of outside business opportunities that might otherwise be considered corporate opportunities, or they might set specific procedures for approving conflict of interest transactions that differ from the statutory safe harbors.
Can they completely eliminate the duties?
Usually not entirely. Most LLC statutes provide that the operating agreement cannot unreasonably reduce the duty of care, nor can it eliminate the duty of loyalty altogether. Often they say the agreement cannot authorize intentional misconduct or knowing violations of law, nor eliminate the implied contractual covenant of good faith and fair dealing that underlies all contracts. But they can often specify types of activities that do not violate the duty of loyalty, provided the agreement and the specification are not manifestly unreasonable. This allows members to tailor the duties much more specifically to the needs and realities of their particular venture.
Can LLC members bring direct and derivative suits against management or the LLC, similar to how shareholders can in a corporation?
Yes, the concepts are very similar here too. Members may bring direct actions against the LLC or other members to enforce their own personal rights as members, such as rights granted under the operating agreement or the state's LLC statute, for example, right to distributions, inspection rights. The key, again, is that the member must allege an actual or threatened injury to them personally that is not merely a consequence of an injury suffered by the LLC as a whole. And members may also bring derivative actions on behalf of the LLC to enforce rights or claims belonging to the LLC itself, typically against managers or controlling members who have breached their duties and harmed the LLC. Similar to corporate derivative suits, members bringing an LLC derivative action must usually show that they first made a demand on the managers or members in a member-managed LLC to bring the suit, or that such a demand would have been futile. The recovery, again, goes to the LLC.
And finally, how does an LLC's life end? How does it dissolve or wind down its operations? Is it similar to corporate dissolution?
The process has similarities, but also reflects the LLC's hybrid nature. An LLC can typically merge with another LLC or even with other types of business entities like corporations, following statutory procedures. It may also dissolve upon the occurrence of various events causing dissolution. These often include mutual consent of all members, the passage of a certain period, often 90 consecutive days, where the LLC has no members, an order from a court, or the occurrence of a specific event identified in the operating agreement as causing dissolution.
What about involuntary dissolution by court order? Can members seek that like shareholders can?
Yes. A member may petition a court for involuntary dissolution under various circumstances, often similar to the corporate grounds, such as managers acting illegally or fraudulently. A particularly important ground in the LLC context, similar to shareholder oppression, is when a controlling member or manager acts in a way that is oppressive and directly harmful to the member seeking the dissolution order. To prevail on this ground, the petitioning member often needs to show that the controlling member's actions violated their reasonable expectations as a member of that particular LLC.
And once dissolution occurs, what's the winding up process?
When an LLC is dissolved, it enters a winding up phase, just like a corporation. During this period, the LLC must 1. Discharge its debts, obligations, and other liabilities or make adequate provision for them. 2. Settle and close its activities. And 3. Marshal and distribute its remaining assets. The order of distribution is typically similar to corporations. First to creditors, then potentially to members for return of contributions, and finally distributing any remaining assets to members according to their sharing ratios, usually as set out in the operating agreement or by statute. The LLC can perform any other acts necessary or appropriate to complete this winding up process. And seeing the LLC framework laid out really provides a fascinating comparison, doesn't it? You can see how it clearly builds on established corporate law principles, limited liability, fiduciary duties, derivative suits, veil piercing, while simultaneously offering significant contractual flexibility, particularly through the operating agreement, in areas like management structure, profit allocation, and even the tailoring of fiduciary duties. This inherent adaptability, this ability to be customized, is precisely why the LLC has become such a prevalent and popular choice in modern business, especially for startups, joint ventures, and closely held businesses that value both protection and flexibility.
Wow. We have really taken a deep dive today into the foundational structures of both corporate and LLC law. It's incredible to trace it all the way from the moment an idea sparks into a potential business entity through its daily operations and seeing how that complex interplay between shareholders or members, directors or managers, officers, and the very specific legal framework truly shapes its destiny and defines who bears the risk at every stage.
Indeed. And understanding these elements, the subtle nuances of formation, the critical fiduciary duties owed by those in positions of power, the pathways for liability when things go wrong, the possibility of piercing the veil, and the distinct life cycles and endgames for these entities, it isn't just academic theory. It's absolutely critical knowledge, not only for legal professionals gearing up for exams or practice, but really for anyone looking to navigate the world of business intelligently. Whether you're thinking about starting your own venture, investing in someone else's, or even just trying to understand the business news you read every day, these principles truly underpin the entire commercial landscape.
So what does this all mean for you listening right now? Well, as you encounter businesses in your daily life, from the local coffee shop that might be an LLC to the giant multinational corporation listed on the stock exchange, or perhaps as you embark on your own entrepreneurial journey, maybe take a second to consider this. How might that seemingly simple initial choice of entity corporation or LLC fundamentally alter the risks and the opportunities for its founders, its investors, and even its employees down the line? And maybe next time you hear about a company facing legal troubles or a boardroom battle, how might understanding concepts like piercing the corporate veil or fiduciary duties or the crucial difference between a direct and a derivative suit give you a deeper, more informed perspective? It really allows you to cut through the headlines and grasp the true legal and financial stakes involved.
And this detailed look really begs an important question as we look forward, doesn't it? In an era of incredibly rapid technological change, globalization, and the emergence of entirely new business models, think about things like decentralized autonomous organizations, DAOs running on blockchain, or complex global supply chains, or AI-driven startups seeking massive rapid growth and maybe public investment very quickly. How do these established, sometimes centuries old, legal frameworks of corporate and LLC law adapt? Or perhaps, how do they struggle to adapt to the evolving nature of enterprise in the 21st century? It makes you wonder how these foundational principles we've discussed today, principles of liability, duty, governance, personality, might be stretched, challenged, or maybe completely reinterpreted to accommodate these entirely new ways of organizing capital and conducting business in the digital age and beyond.
That's a fantastic and frankly quite provocative thought to leave you with. Where does business law go next? Thank you so much for joining us on this deep dive into the intricate yet utterly vital world of corporate and LLC law. We sincerely hope you feel a little more well informed, perhaps a lot more prepared if you're studying, and maybe just a bit more curious about the legal foundations that structure so much of our modern economy.